Jacinda Ardern.
Thank you, Mr Chair. I want to begin first by supporting everything that my colleague Phil Goff has said around why we feel so strongly about the SOP that he has tabled, which essentially reverses the onus as it currently stands in regard to the coroner's involvement in deaths offshore. It was a significant debate at Select Committee. But, Mr Speaker, what I would like to focus my contribution on for this part of the debate around Part 2 are around two elements of the Coroner's Amendment Bill as they relate to what the coroner is able to make recommendations on and the follow-up response that other agencies are required to make to those recommendations, which were two core debates that the Select Committee had. First, I do want to acknowledge, though, that we do have a backlog of cases being faced by our coroners and, much more importantly, by families affected by those coronial inquests and inquiries. And we acknowledge the heartache that those delays cause. So we do understand the ambition, the goal behind this amendment bill, but for us the test always had to be to what extent are we actually foregoing some important checks and balances that the coroner has a role in ensuring are in place in order to reduce that workload, and we feel the bill has gone too far in that regard and actually simply needs to resource the coroner better. Clause 57A particularly highlighted that issue for us, and the Chief Coroner did comment on this part of Part 2. This is the part that sets out what a coroner is able to make recommendations around, and it states, a responsible coroner may make recommendations or comments in the course of or as part of the findings of inquiry into death. Recommendations or comments may be made only for the purpose of reducing the chances of further deaths occurring in circumstances similar to those in which the death occurred. And it goes on to set out some of the criteria for making recommendations. And the first, which I think was actually the sticking point, states under 3A, it must be clearly linked to the factors that contributed to the death to which the injury relates. It must be clearly linked to the factors that contributed to the death to which the inquiry relates. Now, I have a couple of examples where I have concerns as to whether we're narrowing the ability of the coroner to do their job. Now, an example, I'll use a similar example to what was used at Select Committee. If, for instance, there is a finding by a coroner that the core cause of a road accident was the overconsumption of alcohol, for instance, the major factor that contributed to that death was clearly the consumption of alcohol, then leading to impairment for the driver causing the accident. What if, Mr Speaker, that accident also occurred on a bend of road that had had several other accidents in a short space of time, clearly indicating perhaps some danger around that particular piece of roading? Now, it could be argued that that was not necessarily the direct cause of the accident, given the role that alcohol played, but it may have been a factor. And it was an example that a similar example was used around a deliberate road accident. But I think the point is the same, that in fact we're drawing a fuzzy line here as to what a coroner can determine to be a direct factor, a direct cause of death or not, and we may be limiting their ability to draw to our attention additional factors that may be important in that case. And I think you'll find that coroners frequently find situations where there will be supplementary causes around the edges where it's difficult for them to distinguish whether it was a primary factor or not, clearly linked to the death, but still might be relevant to the death. So it may well be that the Minister wants to clarify that that is not the intent of that clause, but it was certainly in the interpretation from the coroners, and surely that's what we should be concerned with. Mr Chair, I want to come to my two SOPs because they're covered off in the next clause, which is something I feel very, very strongly about and relates to the recommendations themselves that coroners are able to make. It's set out in clause 57B. Here it talks about the requirement for a coroner to consult certain persons or organisations on recommendations or comments that they are going to make. So it's very explicit that if there is an organisation person that is directly, Mr Chair,
Jacinda Ardern.
that a recommendation directly relates to, then the coroner must notify the persons of the proposed recommendation or comment. So whilst there is an obligation on the coroner to notify those individuals, there is no reciprocal requirement on those relevant organisations to respond to a recommendation. Now, this has been the subject of a reasonable amount of debate, particularly amongst the coroners. Actually, not debate. They have a very clear view on this, and the view that they presented to the Select Committee was that if a coroner makes a recommendation, surely the least that we could ask for is a response from the relevant organisation, not a requirement that they adopt the recommendation, because there will be recommendations that from time to time we disagree with, or that an organisation or an entity disagrees with. But surely the least that we could require is a response. Where is the harm in that? And I really seek from the Minister a response to that question, because to date I have seen nothing which sets out a reasonable argument as to why we would not want, after all of that investment, that time, that energy, the submissions that are made, the inquiry, the work that goes into a coroner's report is substantial, and then we don't even require a response. Now, we wouldn't do the same, for instance, to a Law Commission report. We might be a bit piffy in our response, but at least we give one. Why would we not require that here? Now, there are some very, very good reasons why, therefore, I've set out in supplementary order papers 146 and 145, just to explain the difference between the two. Under 145, it sets out that persons or organisations must respond to coroners' recommendations. It's very explicit that it must be a written response, describe the actions that they're going to take or plan to take, but does not oblige them to take any actions, must present then that response within 60 days, a reasonable amount of time, to the Chief Coroner, and then that response is able to be made publicly available with a summary of responses reported back every 12 months. It's a very transparent way of collating what happens as a result of a coroner's report. The difference between 145 and 146 is simple. My assumption was that not everyone would necessarily want to require all organisations, because that could include private entities, although I would argue they do need to be included, particularly when we look at, for instance, the hot air balloon company that was subject of a coronial inquiry. It makes sense that we include adventure tourism, private entities. We heard a lot about agricultural aviation and the accidents that occur there. It makes sense for private entities to be the subject of this requirement. But in case people aren't comfortable with that, SOP 146 is a backup, as it were. It narrows the scope of the SOP and only requires government agencies to respond to coroners' recommendations. But I want to leave the final word to the coroners themselves as to why a mandatory response, not mandatory implementation, but a mandatory response is so necessary. Judge Neil McLean, ex-Chief Coroner, stated in an interview 4 years ago that he, and quote, "One step that I've cautiously pushed for is to follow what the Brits do, what some of the Australian jurisdictions now do, and actually make it mandatory, compulsory, to respond to a coroner's recommendations. At the moment, our recommendations sort of can easily, so to speak, die in the ditch, because they go out there, they sit there, they're never actioned." The report then goes on to talk about the fact that in recent to that interview, a 12-year-old died after inhaling butane with a group of friends in Christchurch car park, and that despite the coroners dealing with 28 butane deaths from 2007 to 2011, resulting in numerous recommendations, it was their assessment that nothing had happened as a result. And again, another example, Rotorua coroner Wallace Bain also reported that a Taupo jet ski accident, which resulted in the death of a young person, was then followed by another death just a short time after, who would be alive, later, who would be alive today if his recommendations had been implemented. Mr. Chair, I would like to hear the Minister's response to those SOPs. I believe strongly that the research by Otago University justifies them, as does the Chief Coroner's view.
Mr. Wall.